All right, here we go. Courtroom's in session, and the tension's already thick. The defense is about to plead for mercy. But will this judge have any left to give?
Mr. Roas, you may proceed with argument.
Thank you, Judge. In the updated PSI, the recommendation, the last recommendation from probation is safety continuum.
Go ahead, I'm sorry.
And certainly, Ms. Harris is willing to do that. However, she would ask the court to consider something else given her circumstances. She's, as stated in the PSI, she's heard things about the JCDI program. She would like to have a chance in the JCDI program. Certainly, she feels that the reason that she relapsed was because she had some things going on in her life. She had a couple of cousins back last year that got shot, and her dealing with that herself and seeing the way it affected her mother caused her to relapse. But the reason she's asking for JCDI rather than safety, Judge, she's got a young child, a young daughter who has some medical issues.
Classic defense move, appeal to compassion. They're painting Miss Harris as a struggling mother, not a repeat offender. It's emotional, it's human. But judges have heard this story before. The question is, does her history outweigh her hardship?
Mom has been taking care, Miss Harris's mother has been taking care of the child while she's been in custody, and the mother is here, the grandmother's here this morning, and I've spoken with her, Judge. When Chastity is out and she's taking care of the child, the grandmother says that she takes care of the child and she's a tremendous help to the grandmother taking care of the child. And the child is going to need some surgery coming up. And the grandmother is being overwhelmed right now with that surgery and the medical issues. And for the child and the grandmother, more than for Chastity, Judge, we're asking for you to consider continuing her probation and considering JCDI rather than safety, just so that she can get out and take care of her child. I think Chastity wants to address that with you as well, Judge.
So here's the thing, though, Ms. Harris, and it's a bit frustrating to me. I feel for your family that is helping take care of your child, but it's not.
And here it is, the judge's breaking point. Every word here drips with disappointment. She's listing every chance Harris got and threw away. In legal terms, this is the setup for a revocation, when the system finally says,
not on me if you're not there to do that. And so using that doesn't really go very well with me, because it's you that put yourself where you are. You've already been, you're a convicted felon. You've been given chances at probation that got revoked. You got time in prison. Then you are placed on probation and given this great opportunity for possessing a firearm while you're on probation. You get another case while you're on probation for the first unlawful possession. I give you another chance on probation with a possession of a controlled substance. I get the argument that you need help. I send you to Safe P. You do Safe P. You get out for ongoing support. You go through the drop program. Did well for a little bit, relapsed, and when you relapse, they're trying to get you more help, but there's just not. You've been on the high medium risk supervised caseload. You've been to safety. You have successfully completed the moral recognition therapy. You've been through the transitional treatment caseload, and you've been to the Spinal Tap outpatient center. There's nothing else.
This part's key. She's reciting every rehab program Harris completed. It's not just a guilt trip. It's a legal justification. The court has to show it tried every tool before sending someone to prison. It's procedure wrapped in frustration.
You are making choices now that addiction, at some point, you have to take advantage of the substantial tools that you've been given. Ms. Malfino?
I agree with you. Also, it's concerning to me that in the update PSI, she denies that she has a drug problem when clearly that's a big issue. And I do feel sorry for the situation that she's in.
Going to find, Ms. Harris, that again, you entered your pleas of true to counts 1 and 3 freely and voluntarily. I find those counts true. Also find count 2 true. Find sufficient evidence to find you guilty in each of your cases.
6 years. Calm tone, but the message hits like a gavel to the gut. This is what revocation sentencing looks like. Probation gone. Original sentence enforced. It's not vengeance. It's consequence.
And cause number 17-28222 finds you guilty of the 3rd-degree felony offense of possession of a firearm by a felon. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 20-35466. What level offense is that one? It could get worse. You probably shouldn't talk. It could get worse. I had written down a higher number. So your attorney bought you, or your grandmother.
It's a second.
And cause number 20-35466 finds you guilty of possession of a controlled substance, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. They will run concurrently, which means together at the same time. I'm going to hand you, I need y'all to sign this, please. These were not plea agreements. You do have some rights to appeal. You need to sign that with your attorney showing that you have a right to appeal. And then I'll get you a copy of that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this by now, but I'm required to read this to you. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Roas. And here, good luck to you, ma'am. You can go back with the bailiff. So, Mr. Turner, you were just revoked back in October of 2021 and received a state jail sentence. Whose court was that in? Was that here?
Yes, ma'am.
So I know then for certain that I read to you those written admonishments about not possessing a firearm, right?
Yes, ma'am.
And you have a prior terroristic threat, you have a prior assault causing bodily injury, and you're walking around with some other young person with guns and shooting at random with hoodies on. I mean,
And just when you think it's over, another defendant, another gun. The judge's patience is gone. You can feel it. This isn't just about crime anymore. It's about a cycle that keeps spinning. One case ends, another begins. Same story, different name.
then I've got 1, 2, 3, 4, 5, 6. In the last month and a half, 6 incident reports from the jail where you cannot follow the instructions. At this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an plea agreement that I followed, and so you waived your right to appeal. Understand that you're fairly young, but you've been given some opportunities already, and obviously you're out there doing some things that could lead you to be in here for something much worse, where you've actually shot someone. It's just not... The running around with guns and shooting has got to stop. And all I can think of is the longer I can keep you away from society, probably the better at this point, because you can't learn. You haven't been able to learn from your past mistakes. I hope that you do, and I hope that you do this time and you get out and you change your life. But you're going to have to make those changes. There's help for you out there wherever you need it. There's help in TDC if you need it. But I don't feel like I have a choice today. I'm also handing you, just like I did before a couple of years ago, the written admonishment regarding your ineligibility to possess a firearm or ammunition. I'm required to read this to you again. You should pay attention. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Do you understand?
Yes, ma'am.
All right, you can go back with the bailiff. I feel like I've seen this. We have maybe one of the co-defendants that I did something
nothing
on.
I'm
This
aware
is
of, Your
very
Honor.
familiar to me.
Unfortunately, it's a pretty common fact pattern. It's 4 people riding around the car at 12:30 in the morning. There's 3 guns in the car.
Yeah. Okay.
And I'll just so the court's aware, the driver, Mr. Joseph Matthews,
Mhm.
who was charged with felon possession of a firearm for the firearm that's in the glove box of the car.
Mhm.
He was on parole after taking a plea deal for the offensive tampering with evidence for his involvement in a homicide. Mr. Dorsey, who fought with the police once they discovered a firearm in his waistband, is also a multiple-time felon. And then Mr. Sam has been convicted out of Harris County as a felon, as well as being on probation out of this court, Your Honor. So there was 3 guns in the car with these 4 people driving around.
In a deferred probation motion to revoke a deferred probation, they're typically, you're entitled to a bond, but there is a provision that allows me not to. I think it's just based on the evidence, which is what I'll do. And if there's any other issues, we'll do it that way.
Judge Lewis, can I say something?
Probably shouldn't. Mr. Sam, I'm going to deny your attorney's motion to set a bond in cause number 22-41263, based on the nature of the underlying offense that you're on probation for, which is a robbery, where you were allowed to plead to the lesser included in that case for a probation, and the fact that you have numerous violations, and one of those being a felon in possession of a firearm. Because you also have, it looks like there's a